Everybody be seated, please. Thank you for being back here this rainy morning. I understand Mr. Adams is keeping y'all with some sugar high with some donuts. Is that what I understand? Anyway, next thing I'm going to do is instruct you on the law. You will be allowed to keep these jury instructions with you, so you don't necessarily need to take any notes unless we find a typo or something. But I would ask that you read along with me as I go through them. So everybody has a copy. You did that pretty adeptly. I was trying to follow. All right, as I say, I'd ask that you read along with me as I go through them so that I can be certain that everyone's been through them in their entirety on at least one occasion. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Denise Williams, the defendant in this case, has been accused of the crimes of conspiracy to commit first-degree murder, and accessory after the fact of first-degree murder. Count 1, conspiracy to commit first-degree murder. To prove that crime, the state must prove the following two elements beyond a reasonable doubt. 1, the intent of Denise Williams was that the offense of first-degree murder would be committed. And 2, in order to carry out the intent, Denise Williams agreed, conspired, combined, and confederated with another person, Brian Winchester, to cause first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. First-degree murder will be fully defined for you below under count 2, and I'm not going to repeat it twice. It is a defense to the charge of criminal conspiracy that Denise Williams, after conspiring with one or more persons to commit a murder, persuaded Brian Winchester not to do so or otherwise prevented commission of the murder under circumstances indicating a complete and voluntary renunciation of her criminal purpose. Renunciation is not complete and voluntary where the crime that was conspired to was not completed because of unanticipated difficulties, unexpected resistance, a decision to postpone the crime to another time, or circumstances known by the defendant that increase the probability of being apprehended. If you find that the defendant proved by a preponderance of the evidence that she persuaded Brian Winchester not to commit the murder or otherwise prevented the commission of the murder under circumstances indicating a complete and voluntary renunciation of her criminal purpose, you should find her not guilty of conspiracy to commit first-degree murder. If the defendant failed to prove by a preponderance of the evidence that she persuaded Brian Winchester not to commit murder or that she did not otherwise prevent commission of the murder under circumstances indicating a complete and voluntary renunciation of her criminal purpose, you should find her guilty of conspiracy to commit murder in the first degree, if all the elements of the charge have been proven beyond a reasonable doubt. Count 2. In this case, Denise Williams is accused in count 2 of first-degree murder, a killing that is excusable or was committed by the use of justifiable deadly force if lawful. If you find Jerry Michael Williams was killed by Denise Williams, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Denise Williams may be found guilty of murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jerry Michael Williams is dead. 2, the death was caused by the criminal act of Denise Williams. 3, there was a premeditated killing of Jerry Michael Williams. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If the defendant helped another person or persons commit the crime of first-degree murder, the defendant is a principal and must be treated as if she had done all the things the other person or persons did if 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. If you find that the crime alleged was committed, an issue in this case is whether the crime of murder in the first degree was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime which the defendant did not intend to occur and in which the defendant did not participate and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of murder in the first degree occurred, that in and of itself does not establish that the murder in the first degree was an independent act of another. If you find that the murder in the first degree was an independent act of Brian Winchester, then you should find Denise Williams not guilty of the crime of murder in the first degree. Count 3. To prove the crime of accessory after the fact in count 3, the state must prove the following 4 elements beyond a reasonable doubt. 1, a first-degree murder was committed by Brian Winchester. 2, after the first-degree murder was committed, Denise Williams maintained, assisted, aided, or attempted to aid Brian Winchester. 3, at that time, Denise Williams knew that Brian Winchester had committed the first-degree murder. And 4, Denise Williams did so with the intent that Brian Winchester avoid or escape detection, arrest, trial, or punishment. It is not necessary for the state to prove that Denise Williams' assistance was successful in allowing Brian Winchester to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that Brian Winchester was convicted. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. First-degree murder has been fully defined above under count 2. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, who has been promised immunity from prosecution, or who hopes to gain more favorable treatment in his or her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. The jury is not to discuss any question that a juror wrote that was not asked by the court and must not hold that against either party. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged in the indictment or not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. All right, let's look at the verdict form with me, please. I think it's pretty self-explanatory, but you have 3 counts. First, you have, as to count 1, you would choose either the defendant is guilty of conspiracy to commit first-degree murder or not guilty. You would check the one option you unanimously agree upon. Same as to count 2, either guilty of first-degree murder or not guilty. Again, you would check the option you unanimously agree upon. Same as to count 3, either guilty of accessory after the fact of first-degree murder or not guilty. So when you get through, you should have 3 check marks on your verdict form. It will be dated and signed by the foreperson. The foreperson will bring the verdict form back to the courtroom with them after you've completed your deliberations. Sometimes I get a question from the jury whether everybody has to sign the verdict form. No, just the foreperson signs on behalf of the jury. I'll go over the concluding remarks after the attorneys have made their closing arguments. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Mr. Fuchs.
Thank you, Your Honor.